for deed. Now, what I'd like to do is talk about foreclosures now for 15, 20 minutes. And then we're going to do one or two other things, and then we're done. We're going back to mortgages now. And we're going to talk about what happens in a mortgage foreclosure and what priorities are and how they work and how a foreclosure works. And this is going to be kind of fast and furious, unfortunately, because the clock is working against us. All right. Let's say here in the year 2000, I got notes merely to remember to throw all this stuff at you. In the year 2000, you've contracted to buy a piece of property. You're a real estate broker. You're going to buy a building for $400,000. $400,000, and you're going to get a new mortgage for $300,000. Okay? You're buying a 2,000 square foot building, and you're going to move your real estate brokerage firm in there. And the fair market value of the property, of course, on that date in 2000 is $400,000. That's why you agreed to pay $400,000. So you do your 30, 60 days of due diligence, and you go get your loan commitment from your lender, and then you have a closing. So later in the year 2000, the seller is going to do a deed to you, the buyer. In that deed, the seller is going to reserve an easement. He's going to reserve an easement because he's next door and he wants to use part of your driveway. So he's reserving an easement over this building here, part of your parking lot, for his big fat Hummer to be able to get it in and out. And so he needs 10 feet of your driveway to get in and out. He's going to reserve it. In addition, so you're going to have this closing, and you have negotiated a $300,000 first mortgage. First mortgage to bank number one. And your next door neighbor, good friend, is your banker, and he gives you a real great low interest rate, wonderful terms. You swear, oh, I'm going to pay you back, don't worry about it. And that's cool. And of course, at that time, still, at the time of the closing, the property is worth $400,000. Okay, things are going well. 2002, a neighbor on the other side comes to you and says, well, would you give me an easement over your parking lot too, on the other side? And you say, sure. So you give an easement over the parking lot to another neighbor. But he's not so smart. He doesn't record. Remember, this seller's easement is reserved in the deed. When the deed's recorded, by God, that's recorded. The easement's recorded. He's got a recorded easement. So you're rocking along fine. Seller's got a recorded easement. You got a $300,000 mortgage. You're making your payments. A couple years later, you give an easement to a guy on the other side, but he doesn't record. In 2003, your business is going real well. You decided to go get a second mortgage to bank number two for $150,000. That's because the property has appreciated. Instead of $400,000, here 3 years later, things are going well. Your property is now worth $600,000 fair market value. So of course, bank number two is thinking, this is cool. It's worth $600,000. He's got a $300,000 first, and he's making the payments. Sure, we'll loan him $150,000. Still got plenty of equity. He still has $150,000 equity, so let's go ahead and loan him that money. So, come to 2007, and although the good thing is that your property now has a fair market value of $700,000, because we're kind of at the peak here, but your business goes to hell in 2007. You stop making payments on this mortgage that had a real high interest rate because you can't afford it anymore. So you're not going to pay the second, and but you're going to keep paying the first because he's your buddy and he's your next door neighbor, but you just can't afford to pay the payments on that second anymore. And you're not going to pay the 2006 real estate taxes. And later that year, you're not going to pay the 2007 real estate taxes either. And then things get really bad. Later in the year, a judgment creditor, because your business has really gone down the tubes, gets a judgment against you for $100,000, and you quit paying IRS the money you've been withholding from your employees, and IRS files a $50,000 tax lien against you. Things are real bad. The worst thing of all is, it's now 2008, and the value of your property has now gone down to $400,000. And if you don't think that happened, you weren't paying attention. Any number of people had property worth double in 2007 what it was appraised for in 2008. Now the fair market value of your property is only $400,000. Pretty soon, bank number 2 is going to foreclose. Bank number 2 has had it. They've rocked along for a while. You haven't showed them you pay the taxes. Bank number 1 is asleep because you're making payments to them. They don't really care about the real estate taxes. You're making the payments. They're happy as a pig and you know what. And they're not worried about it. Bank number 2 realizes you're not paying the taxes, and of course that you're not making the payments. So in 2008, at the end of the year, bank number 2 decides to foreclose its mortgage. Okay, now, it's been writing you letters ever since 2007 when you quit paying, saying you better pay. It accelerated its balance. Instead of its payments of $1,500 a month, it now says pay me $150, and late charges already and interest in terms you haven't paid. They're going to foreclose, and already there's $175,000 due at that time. Now, of course, if you wanted to, you could send in $175,000, but of course you don't have it. Your business has just gone to hell. So what happens? Here's what happens. Here's what happens in a foreclosure. Bank number 2 is going to foreclose. Here's the first thing it does to file a lawsuit. It files a complaint. Every lawsuit begins with a complaint. And in that complaint, it says basically, we had a note mortgage for $150,000. You didn't pay it. Your Honor, we want you to sell the property so I can get paid. So bank number 2 can get paid. Who are they going to sue? Let's think about it. The first person they're going to sue, of course, is you. For a couple of reasons. Number 1, because you signed a note mortgage. And number 2, because you're the owner. And the only way they're going to be able to sell the property is if they take it away from you. So the first defendant they're going to sue is the owner. Now, who else are they going to sue? They're not going to sue Bank 1. Bank 1 is in front of them. They can't do anything about Bank 1. Who else are they not going to sue? They're not going to sue the seller that has a recorded easement. Why? These mortgages, this mortgage of $300,000 was recorded in the year 2000. This easement was recorded in the year 2000. When was Bank 2's mortgage recorded? 2003. They can't sue people in front of them. They're ahead of them. The only person they can sue is the owner, of course, because the owner signed their note mortgage, you. And also because in order to have a foreclosure, they got to take the title away so the clerk can sell it. So what we're getting at here, and this is going to be the bottom line of all this, but let me go ahead and punchline it now. You cannot eliminate anybody who's in front of you. you can only eliminate people who are behind you. So who are they going to sue now? They can't sue the bank. The bank is on there, bank number one, with a $300,000 claim, tough. And the seller has an easement over the parking lot. That's on there. Now, this guy's real screwed. He didn't record. They don't even have to bother suing him. He doesn't have anything. But out here, what are they going to do? Well, taxes aren't paid. Does that mean they can sue Broward County and wipe out the taxes that didn't get paid? No. Taxes are first lien priority, right? These are a prior lien to even this guy. Nobody wipes out the real estate taxes. That's just tough. The taxes are on there. Somebody's going to pay them. Whoever ends up owning this thing's going to pay them. Now the bank can, if it wants to, pay them and add them to the balance if they're worried about it, but they'll probably just leave them out there because it's all, remember we said it takes about 3 years before a deed gets issued for unpaid taxes. So they'll worry about, they'll cross that bridge when they come to it if they have to pay them. Right now they're going to leave them unpaid. But the judgment creditor, let's say, was MasterCard. Of course they're going to name MasterCard. So the second defendant will be MasterCard, who had the $100,000 judgment. We're going to sue them and wipe them off the property. And how about IRS? Let's sue them too. Let's sue United States of America to try to eliminate their $50,000 tax lien. Okay. Anybody else? Not really. That would clear up the title, basically, from here forward. If this lawsuit is successful, they will take away the owner's title. They can't wipe out the real estate taxes, but they can wipe out a judgment creditor, and they can wipe out a tax lien. Now remember, through all this, unfortunately with all this going on, and their balance is already $175,000, and there's already a $300,000 loan on there, remember the damn property is only worth $400,000. So we're already going way underwater here. But they got to do it. They got to do something. So they filed this suit. So here's what happened. They filed this complaint, and they filed something we've talked about before, notice of lis pendens. They record in the public records notice of lis pendens. Remember what that means? Notice of lawsuit pending. And what that does is that tells anybody who examines the public records that this foreclosure lawsuit is going on, and the bank is making a claim to sell a property. What that does is that prohibits you from giving a deed to somebody else. Anybody who takes any interest in this property now takes subject to the outcome of this lawsuit because they take their interest after the notice of lis pendens. So, they serve the complaint on all these people. They all have 20 days to answer, except the IRS. They get longer to answer, but everybody has a certain period of time to file an answer. Nobody files any good answer like, we paid you off or something. There's no defense to one of these damn things. And if somehow MasterCard or IRS thought they were in front of bank number 2, now's the time for them to come in and they better say why. But they're not. Hell, they were recorded 4 years later. They're after bank number 2. So the court, the judge, now this is a case in front of the judge. This is a judicial foreclosure in Florida. The judge is going to enter an order called a summary final judgment, but it really is a final judgment of foreclosure. And what that's going to say is, they're going to add attorney's fees and stuff like that, and they're going to say $190,000 is now the total due on the debt to bank number 2. And the judge is going to say, okay, owner owes $190,000 to bank number 2. And MasterCard, you're inferior. You're out. USA, you're inferior. You're out. Let's have an auction and let's sell it. By law, the auction has to be 30 days out. So the judge is going to say right here in the foreclosure what the date of the auction is. So he's going to say there's going to be an auction at the courthouse on the courthouse steps, but it's going to be online now, we all know. But there's going to be an auction, and it's going to be 30 days out. And there's going to be a bidder at the sale. And at that sale, somebody's going to bid. Whoever shows up and buys this will get the winning ticket from the auction. He will get what's called a certificate of sale. That means you won the auction. And the certificate of sale, after 14 days, statutory right of redemption, actually it's a 10-day right of redemption, but the clerk waits 3 days. 14 days after the certificate of sale, the clerk will give a certificate of title to the winning bidder. And that certificate of title will transfer the title to your building to the bidder at the sale. Now, think it through. Who's going to bid at the sale? At the sale, they know there's if they've examined title, and if they don't, this is great, bring them on. But most sophisticated buyers are going to examine the title. They're going to see that there's a $300,000 mortgage on there. And they're going to see that a bunch of taxes aren't paid. And best case, the property is worth $400,000. But bank number twos do $190,000. So realistically, who's buying this at the sale? Bank number two. That's the only possible buyer. Who else could possibly buy this at the sale? And here's why. Bank number two gets to bid at that sale $190,000 of monopoly money, free. The bank can bid up to $190,000 because that's how much it's due without paying a penny, because it's paying itself. If some buyer came in and put $200,000 in the pot, it would all go to bank number two anyway, right? So bank number two is entitled to the first $190,000 of auction proceeds. So that means bank number two gets to bid at the sale up to $190,000 free. Not free, they're out $190,000. But the point is they don't have to put out any more money. Hell, they've already put out another $190,000. So bank number two is going to end up buying this at the sale. And what's going to happen? Think about this now. Bank number two gets it at the sale. Bank number two now owns the property. Bank two owns it. Now the owner. It's got a $300,000 first mortgage on it. And it was worth $400,000. So what's the value of this property to the bank? Minus a couple of years real estate taxes. $100,000? That's all it's worth. It's worth $100,000. But the bank was due $190,000. So what's the bank going to do? The bank's going to sue you for that other $90,000.
So
That's called a deficiency, or what? That's called a deficiency decree. The bank was entitled to $190,000 under the note that you signed. It was only a $150,000 note, but it grew because you didn't make payments, attorney's fees, court costs, late charges. It grew up to $190,000. You signed the note, and the bank's going to want to be paid by you because you signed the note. All the bank got out of the foreclosure sale was a piece of property worth $400,000. Liens are wiped off it. That's good. But it's still got these two things on it. So really, the bank maybe only got, let's say these taxes were $7,000 because they were past due, and then $5,000, let's say it was another 12. Really, the bank only got, rather than 100, the bank only got 88,000 worth. This property is only worth 88,000 to the bank, but you owe the bank another 190. So the bank comes back into court and says, Your Honor, we only really got 88. Real estate broker who signed our note and mortgage agreed that we were to get paid everything due under our note, which is 190. Your Honor, give me a deficiency decree against our borrower for $102,000. And the bank is going to come after you for $102,000. That's how all this stuff works. Now, let's talk about one or two of the other things we talked about. What about a short sale? What about a deed in lieu of foreclosure? You think you could go to the bank and say, you know what, bank, I'm not going to pay anymore. How do you like me to deed it to you? Can't do it. Got other liens on there that have to get wiped out. How about a short sale? A short sale for $400,000? Bank one is going to say, I want my whole 300. This bank is not going to agree to a reduction, and it can't because these liens are still on there and they got to get wiped out. So really, the alternatives to foreclosure that we talked about, they just don't work here. When you've got a lot of title problems, you can't use those two alternatives. This bank, at some point, is going to get real unhappy because clearly you're going to quit paying them. Even though it was your next door neighbor buddy, you don't even own the damn building anymore. So you're going to quit. What's it going to do? It'll file a foreclosure. By that time, the only person to sue will be bank number two, because everything else has been cleared off the property. Bank number two is going to have to come up with $300,000 to keep from this loan getting foreclosed, because it's subject to it. So all I want to say simply is, what people do in these situations are totally driven by the economics of what's the property worth. If this property had been worth, at this time, $900,000, the situation would be totally different. You'd have sold the damn thing and paid everybody off and still put some money in your pocket. Or if you didn't, nobody would be this worried about bank number one having a $300,000 lien on there because it's worth $900,000 now. But it's because the value went down, the economics of the value of the property, with it really being worth this, is what means everybody's going down the tube. And there's one more point that I want to make that a lot of people misunderstand. People also think because in this foreclosure, bank number two wiped out MasterCard and wiped out IRS, doesn't mean you don't owe them anymore. All it did was eliminate their lien on this piece of property. You're still going to get sued by MasterCard for $100 grand. And you're still going to have IRS come after you to collect its $50 grand. All they've done in this foreclosure is cleared the title to this one piece of property and everybody who had liens on it. That's all we're talking about. Get them off this piece of property so we can sell it. But that doesn't mean they're paid. They're still coming after you. Questions? That's it. That's what a foreclosure does. A foreclosure, so here's the punchline. A foreclosure eliminates everybody recorded after you who is called junior to you, but it can't eliminate anybody in front of you. We said these priorities were all established by when people recorded. And therefore, people who record after you, you can wipe off the piece of property. You're not canceling their debts, you're not declaring them paid, you just say, get them off my piece of property so I can deal with it. But the people who are in front of you, they're in front of you, and they're staying in front of you, there's nothing you do. Okay, that's how foreclosure works. Okay. I want to do one more thing quickly, and then we're going to take a break. And I'm going to make this short. I want to talk about ethics. We're finished with our material in the text. The name of this course is Real Estate Law and Ethics. The text has talked about ethics a bunch, and we've dealt with a little bit about stewardship of land and green development and vacant lands and what you do with property and stuff like that. The syllabus for the course, which of course I didn't write, says ethics is a branch of philosophy applied to business ethics, and we will study methods of ethical theories of practical use to a business person. I have no idea what either of those things mean. I want to talk to you quickly about what ethics means to me as I think it applies to you as a real estate developer. And it's short, and it boils down to simply doing the right thing, and what goes around comes around. And you've heard all these things from your parents and grandparents and ministers all your life, but it's really going to apply here, because you're going to get a reputation. And people are going to know either you're good for your word and you do what you said you do, or the one time you weren't, that's going to spread like wildfire, and nobody's going to want to deal with you. You can build a reputation, but you can't buy one, and you can destroy it in one deal. There are two reasons that you want to do the right thing. Number one, because you're going to feel better about yourself and what you're doing. But most importantly, people will bring you deals. Realtors will bring deals to you if you're honest and you keep your word and you close and you do what you said you'd do and you treat people fairly. Realtors will bring tenants to your projects. Realtors will bring you deals to invest in or buy. You don't want a reputation for screwing realtors and trying to stiff them and trying to find out who's their client and then go behind their back and try to do a deal and stiff them out of a commission. That word spreads real quickly too, and they just don't bring you deals anymore. I want to tell you a quickie story of a Miami. It was a firm in Coral Gables in the 80s. It was acquiring and redeveloping buildings all over Miami, all over Broward County and Dade County. They were incredibly successful, but they were very aggressive and adversarial. And every deal they got into ended up in litigation of some type, because they wanted to fight about everything. And every time they did a deal with a bank, and it got time to close, they'd end up suing the bank. Their lawyers were obnoxious. The guys were pushy. Banks' lawyers didn't like dealing with them, because they were always having to worry about getting sued. And pretty soon, the word got around, just don't deal with them. Good banks were turning down good proposals and good loans because they didn't want to deal with these people, because they were aggressive, adversarial, nasty. They sued you for a hangnail, and pretty soon, nobody would deal with them. And then pretty soon, nobody would do deals with their very high-class law firm, because it meant you probably were going to get sued for something. And quickly, they had to find out that a real estate deal is not supposed to be an adversarial transaction. A real estate closing and a real estate loan are supposed to be among people that want to do the deal. Seller wants the money, buyer wants the property. Lender wants to make the loan, borrower wants to borrow. It's not all about setting up the other side and seeing if you can sue them for something to gain an extra quarter of a point. You might win that one, but they'll never deal with you again, and nobody else will. So my spiel on ethics is do the right thing in every deal and make everybody happy if you can, and always give people what you can give them. You'll find people negotiating for certain things in deals that you think are really stupid, but they don't hurt give them to them. They think they're important. Throw them a bone. They want nah, 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 and you don't care, even though you think it's stupid, give it to them. You make them happy, you have a happy deal, they tell everybody you're a joy to deal with, other people will come want to do deals with you. You don't have to win every little battle over every little thing, because people will remember. All they will remember about you is the fight. So, the message is good ethics will allow you to do more deals and better deals. And lastly, they will make your lawyer proud to represent you. And that sounds like a silly thing because that's coming from a lawyer and thinking it's all about the lawyer. But here's what it's about. Lawyers judge people new in a deal by who their lawyers are and who they associate themselves with. Who's the other side's lawyer? Are they honest? Are they trustworthy? And if your lawyer is proud to be representing you and doing the right thing, that message is going to go across to the other side. And it's not only going to translate to the other lawyers, it's going to translate to the other client. And the other deals that that law firm does. And if all of a sudden you call your lawyer one day and you say you want him to represent you on a deal and he comes up with some reason why not, the reason why not is because in the last deal you embarrassed him. Or you reneged. Or you didn't do something you promised you did. And the egg was on him and his face and his reputation, and he ain't going there anymore. So, of course, this doesn't all boil down to it's all about lawyers. It's not. It's all about you. But the team you surround yourself with is important, and it carries your message of how trustworthy you are. And then they spread the word quickly to others, and that will bring other people to you. So anyway, that's the end of my spiel on ethics. That's the end of our presentation of all of our course material. I want to thank you for your attention and your courtesy, and we're done. Here's what we're going to do. We're going to take a 15-minute break on that clock. And here's what I am required to ask you to do in the next 15 minutes. Y'all each received an email where you were to evaluate your instructor. I'm going to leave the room for 15 minutes and I'm going to ask you all to fill out that evaluation. If you do it, great. Nobody can make you do it. They can only make me leave the room for 15 minutes and ask you to do it. So that's what we're doing. So we're going to take a 15-minute break. We're going to reconvene a little after 8:30, and we'll start your exam at 8:35, but be here a couple minutes beforehand probably so I can pass them out. So we'll start the exam at 8:35, and in the meantime, if you'll do the instructor's evaluation, the administrators of the program will be grateful. Okay, thank you. See you in a few. Good.